BP added more than $70 billion to the U.S. economy last year by making investments from coast to coast. Investments like acquiring America's largest biogas producer, Archaea Energy, and starting up new infrastructure in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
The stress and crowds of holiday shopping can put a damper on your holiday spirit, and you don't always find all the perfect gifts you're looking for. The Virginia Lottery's games make easy and tremendously fun gifts for all the adults in your life, even you. Celebrate the season of gifting with Virginia Lottery Scratchers and online instant games. For more info, visit valottery.com/holiday.
Hey, it's Ryan Holiday, host of the Daily Stoic podcast. When I bought my first house in 2013, part of the way I paid for it was we would rent it out on Airbnb in Austin when there was South by Southwest or F1 or ACL. And then later, when that tiny little house became my office, I would work there. I'd do my writing during the week. Then on the weekends, we'd rent it out to people who were coming in from out of town on Airbnb. And you may be sitting on an Airbnb and not even know it. You've probably had the same experience. You stayed in an Airbnb and thought, this is doable. Maybe I could rent my place on Airbnb. And it's really that simple. You can start with a spare room or you can rent your whole place. Maybe you're traveling to see friends and family for the holidays. While you're away, your home could be an Airbnb. Your home might be worth more than you think. Find out at airbnb.com/host.
Content warning, this episode contains discussion of the murder of 2 girls.
Shay Hughes is a great source of legal analysis about the Richard Allen case, and other criminal cases as well. He's a criminal defense attorney in Indiana, and you can find him on Instagram, where he posts his insights under the name Hoosier Public Defender. He is definitely worth a follow.
He has also, of course, shared his thoughts with us on the show in the past. It's been a while since we've had him on, though, and a lot has happened since we last talked. We decided to ask him back on so we could get a defense attorney's perspective on the Franks Memorandum the Allen defense team recently filed. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, discussing the Franks Memorandum with the Hoosier Public Defender.
What's your overall impression of this Franks Memorandum?
I kind of have mixed feelings about the memorandum itself. It's very argumentative. It's not the typical memorandum that you would see as it relates to a suppression motion. It's not a memorandum that, I would lay out or draft myself. So, there's that, but I think parts 3 and 5, I kind of get where they're coming from. I do think there is some important arguments to make, but overall, I'm kind of mixed about it. I think this was their attempt to kind of publicly get out their case, because I think there are many things within the memorandum that aren't relevant to a suppression, discussing, the fact that certain items haven't been received in discovery, or talking about flaws in the investigation, or, what's transpiring down at the Westfield DOC with Richard Allen. Those things aren't really relevant to a search warrant, more specifically a search warrant that was issued in October of 2022. So just kind of mixed emotions about it, mixed feelings about the memorandum.
Yeah, absolutely. I wanted to start off with the positives and if we could discuss maybe some of the better points that you think were raised, or at the very least things that you think are intriguing and can speak to defense strategy.
Yeah, I would point out parts 3 and 5. I think that's pretty important. What's stated there, I think part 3 is in reference to a couple of the witnesses on the trail and information that was omitted. I do think that information is material, and it probably should have been included within the affidavit. Part 5, I think, is really important, and I know there's kind of a dispute about the time with, I think, Lieutenant Dan Doolin and what was said and so forth. I think a bigger material fact, and this doesn't seem to be disputed given the state's response that was filed, is that allegedly Richard Allen, told the affiant that, he arrived at the trail around noon, he left around 1:30. And, that's, I think, huge in reference to the timeline as it relates to this case.
Those are some good points raised by them, and certainly some questions that have not been answered at this point as far as the state goes. Do you see this going to a Frank's hearing?
I think so. I mean, I think it doesn't seem to be from the state's response that omitted information, is being contested by the state. I don't definitively know one way or the other, but I think as it relates to what's been omitted from a couple of the witnesses, what's been omitted from Richard Allen's statement to police, yes. As it relates to the cult and the odorous, information, I really don't know. I mean, keep in mind that if the same judge is reviewing other search warrants as it relates to the case, and this information was provided to him previously, then the courts have basically said that you're not misleading a judge that, has previously reviewed affidavits as they relate to a certain investigation. And the other thing to keep in mind is, affidavits don't need to be voluminous. They don't need to include every detail. Just because there's probable cause for one suspect doesn't mean there's probable cause for another suspect. It's not zero sum. In other words, because there's not, sometimes it does, but just because one person has probable cause, it doesn't take probable cause away from another suspect. Mm-hmm. So, whether or not that comes into play, I doubt it. To me, again, I think the material portions of this memorandum are parts 3 and 5 as they relate to the suppression.
That makes a lot of sense. And you mentioned the sort of, I suppose, what do you think it would take for Judge Gull to say, these Frank's issues are so bad that I will throw out the search warrant? I suppose. Do you think we could be getting into that territory just from what we've read so far?
Well, I think the memorandum certainly weakens the search warrant, the affidavit. I don't feel as good about the affidavit, as I did prior to reading this memorandum, right? Mm-hmm. I mean, there are certain facts that were, that appear to be left out. Whether or not that gets you there, I don't know. I think this is going to be kind of a judgment call. I think you can make an argument on either side, but it's difficult, challenging search warrants. I can ultimately see, a court saying, well, even considering that, there's sufficient probable cause given the clothing, given that there were 3 girls on the trail that described him or described somebody wearing this clothing, and then he acknowledges in his own statement passing these girls. So there might be enough based upon that.
Right, because the timeline definitely is thrown off by the possibility that he said he left at 1:30, although that sounds like it could be brought back into play by if the girls are proven to be there past 1:30, I suppose, then it kind of gets into, and he said he saw them, then it wrinkles it up even more.
Right. Look, and going back with Lieutenant Doolin, police report or his tip or however you want to refer to it as, he mentions that Allen stated to him, being on the trail, 1:30 to 3:30. And obviously, Alan disputes saying that and believes that it's being taken out of context. Unfortunately, so far, we don't have a recording, it looks like, of that statement. I just envision that being difficult to challenge during any type of evidentiary hearing. You can discredit Lieutenant Doolin by saying, you claim to have recorded this, you have not provided the recording. 5+ years have passed, you still cannot locate this recording. No one followed up on this information for 5+ years. But does that somehow make it materially false? I don't think so. It would, in such a scenario, the only way really is to have Richard Allen testify and bring some context to that conversation. I just can't imagine any other way of doing so if you don't have a recording. He's saying one thing. Well, the other side of that party is unfortunately your client. You have no one else there that witnessed it. So, unless he testifies, I just don't see how you're going to be really able to challenge that.
And as a defense attorney, can you explain to our listeners why it is such a risk to have a client testify in a high profile and emotionally charged case like this?
Well, I have a little bit different approach than I think most defense attorneys do, where I'm not necessarily fearful of putting clients on the stand. And the reason for that, to me personally, your client should, out of any other witness, out of any other party, be the most knowledgeable about the case, right? If you're doing what you're supposed to be doing, you're reviewing the discovery with them, you're thoroughly going through their testimony, and they should be sufficiently prepared. I think the best way to ultimately address it with your client is to ask the difficult questions on direct. There is a prohibition in the rules of evidence of cumulative evidence. That's kind of where you get that asked and answered objection. If I ask something on direct, you can't go back on cross and ask the same thing. And my, kind of philosophy on it is, a client should be comfortable answering questions to me as compared to opposing counsel. They're used to me. They're used to my delivery, my questioning techniques. So, I personally kind of have probably an unconventional thought when it comes to clients, taking the witness stand.
But it makes sense given that, it can be so important for the jury to hear from somebody in some of these scenarios, in order to get to that place of like, okay, now I'm maybe questioning the prosecutor's version of events.
At the Murder Sheet, we spend so much time digging into crime stories that sometimes it's difficult to find the time to plan out and cook elaborate, nutritious meals. That's why we are so excited about our sponsor, Factor, America's #1 ready-to-eat meal delivery service. Our sponsors make this podcast possible. So if you go to factormeals.com/msheet and use our special code MSheet, you're not just getting half off this high-quality meal plan. You're supporting us too.
So I'm obsessed with Factor. I had their creamed corn chicken and their tomato basil chicken risotto recently. Both were delicious. That risotto in particular was amazing. Plus, the whole process was a breeze. All I had to do was pop the meal into the microwave. The food was tasty and flavorful, which is no surprise given that each recipe is specifically crafted by chefs and approved by dietitians.
Having Factor during the hectic holiday season has been a boon, especially with us pumping out so many episodes. Head to factormeals.com/msheet and use code MSheet to get 50% off. That's code MSheet at factormeals.com/msheet to get 50% off.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Hey listeners, this is Candace DeLong, the host of Killer Psyche. Imagine all your audio entertainment available in just one place. That's what the Audible app is all about. With Audible, you can always find the best of what you love or discover something new. Audible has an incredible selection of mystery and thriller titles and originals like Something Ain't Right by Roger and Zachary Stringer, The Space Within by Greg O'Connor and Josh Fagan, and Moriarty, an Audible original. Membership includes access to Audible originals, podcasts, and tons of audiobooks that you can download or stream as much as you want. And as an Audible member, you can choose one title per month from an ever-growing catalog of titles to keep. The Audible app makes it easy to listen anytime, anywhere, whether you're traveling, working out, doing chores, wherever your day takes you. New members can try Audible now for free for 30 days. Visit audible.com/DeLong or text DeLong to 500-500.
I was wondering, kind of maybe stepping over to the side of things that maybe are a little bit more eyebrow raising. Obviously, and Nick McClellan, the prosecutor, pointed this out, a lot of what they wrote here has nothing to do with the underlying Franks issues and reads more to me like a very salty press release. And what would be the strategic value in laying out your entire case for the public and media consumption ahead of trial?
To play in the court of public opinion, so people kind of, I don't know, they may come in with preconceived notions of your case coming in. They may be skeptical of the state, heading into trial. I can't really speak for them and their motivations, but, I agree with you. I mean, I think it was more of kind of a press release, was argumentative, and was kind of, their opportunity to present their defense. So, the reasoning for it, I think, in some respects, I kind of get where they're coming from. There's been a number of press conferences held. 2 sketches have been released. Cell phone footage was released. They've been able to put out their narrative. At that June hearing, that kind of bothered me, what transpired there with, discussing this allegation of incriminating jail phone calls. I kind of have trouble how that relates to someone's placement, in DOC as compared to a county jail. And then simultaneously saying, well, we don't really want anyone to talk about the case. Going back, to October, how this kind of was just oddly kind of rushed through, right? I mean, there's news reports of, something relates to Delphi, right? On Friday, that there will be an announcement on Monday, and then come to find out the initial hearing had already occurred on Friday. I think there's an issue with one of the reporters trying to get the daily log from, Indiana State Police. Indiana State Police refused to hand it over and basically said, we only need to create the record in 24 hours. We don't need to provide it to you, make it publicly accessible in 24 hours, even though the public access counselor has come out with an advisory opinion stating otherwise previously, involving Indiana State Police, no less. The safekeeping order, the fact that you send this guy off to DOC without counsel, without an opportunity to be heard, along with the fact that there was no evidence presented, that he posed a danger to others or was facing any threats, right?
Mm-hmm.
I mean, I think a lot of it was just pretty argumentative. So, I kind of get where they're coming from in some respects.
Yeah.
I'm sure if I was Richard Allen's counsel, it would upset me. With that said, would I have laid out this memorandum the way they did? Probably not.
Why not? What's the risk?
I don't know. I don't want to sound kind of sanctimonious, but it's not something I would necessarily do. I mean, I think for some people it may turn them off.
Yeah, we've heard from a lot of people who take it very seriously and have appreciated the blunt tone. I think it did turn a lot of people off, in fairness. I think it's kind of your mileage may vary sort of situation depending on people's personalities or how they view the document. Is there, I guess for me, is there a risk of seriously taking the judge off in this case? Of course, the judge is the one who set up the gag order. And if there's a view of people not taking the gag order very seriously in this respect, is that a risk?
I think, well, there's always a risk, yes, of upsetting, the judge that's presiding over the case. As it relates to the gag order, to me, this doesn't violate the gag order. It's not a statement made outside of court. It's being filed, as part of the record. Can a judge come back and say this is not a typical memorandum that you would see? Yeah, I think that's fair to say. Until the conclusion of this memorandum, I don't think there's really any legal analysis, right? There's no case citations at all. There's no legal authority. That's another reason why, I wouldn't have drafted it this way.
One thing that's gotten some attention is footnote 15, and this is the part in the document where they suggest that perhaps Richard Allen wants to say that he was forced to confess by the guards, and then in the footnote they say, of course, he hasn't actually said this to us, but it's possible. What's your reaction to that?
I really don't have an opinion of it. What I can say, the whole issue with the guards and everything, and this kind of bothers me because I think this probably should have been addressed back in June. And I think in the following footnote, they basically allude to as much that they were aware of this, made these observations about the guards and all this, but then it's not brought up in June. So I don't know. I'm kind of indifferent about it.
Some people commented and asked us about naming alternate suspects. The defense actually, Kevin and I have debated amongst ourselves. Kevin notes that they're not necessarily saying these are the guys we think did it outright, but they're saying these are people that the police should have looked into more, and they're seemingly sort of sketching out their theory of the crime, in my view at least. Is that unusual in a filing like this to name specific people like that?
It's somewhat difficult for me to answer that just because you don't typically have a case like this.
Right. It's so unusual.
To begin with.
Right.
So I can't say if it's typical or not. I can say overall the fact pattern itself is unusual. As far as it relates to the search warrant, I get where they're coming from by essentially saying, well, there's other suspects out there. That information should have been included in the affidavit. And by not mentioning that in the affidavit, in other words, by there being other suspects, that would diminish probable cause against Richard Allen. When it's diminished, you don't get to probable cause, therefore the search warrant's invalid. Okay, I get that. But like I said earlier, there could be multiple suspects. It's not zero sum. In terms of naming them and so forth, I think you'd have to show kind of, identify somebody else in order to prove that this is material information that was omitted and state the reasons why. With that said, though, there are a number of issues with what they claim. I have trouble believing that a lot of this information that they provide as it relates to other suspects would even be admissible in trial. And if it would, even be credible to put in a search warrant. For instance, the statements that, Amber Holder makes, that's hearsay within hearsay. That is not trustworthiness. That's something that I would not feel comfortable if I was a law enforcement officer putting in a search warrant.
Yes. And I think that underscores what we're all interested in learning, which is, was the Odinist theory dropped because ultimately there wasn't enough there, or there wasn't really anything there that was, you could actually make a case against somebody? Or is this a situation where it was dropped too early and they missed opportunities to get to probable cause? And I think that's, everyone's focusing on the Odinism angle because it's the most salacious. And I mean, listen, they wrote 100 pages about Odinism. So yeah, that makes sense that people are focusing on it. But the underlying issues, I think, are more of what does it say about the health of the investigation?
Right.
That's just my take.
Right. I think that's a better way to think of it. Again, I don't know how much relevance this is going to have. I think it's going to have little impact as it relates to suppression. I think this was more of a preview of what to expect during any trial. But even then, I think a lot of this information that they provide, I think much of it is just not going to be admissible during trial.
Were you surprised that the prosecution didn't push back harder on the idea that law enforcement had lied or misled in the affidavits?
I was surprised by that there really wasn't much of a response. I think the biggest thing that I took away from the response was they don't really seem to dispute, Richard Allen's statement in October that he said he was on the trail from, I think, what was it, from noon to about 1:30. And then there's not much, I think, about the other two witnesses either. I was somewhat surprised. The only other comment, about state's response is, I don't want to get kind of in the legal authority here, but, they mention and rely on Litchfield for their Indiana constitutional argument. I don't really understand that. Litchfield is a case that challenged a warrantless traffic search in talking about the reasonableness of police officers. That Litchfield applies to warrantless searches. I don't recall, and again, I quickly read through it, but I know at least on their first response, they didn't mention this either, is, no mention of good faith exception, that at the end of the day, officers relied on this in good faith. Now, with that said, their suppression kind of goes at the heart of that anyways. I mean, good faith doesn't apply if the warrant's based on false information or the warrant's facially deficient, which you'd have to address anyways, given, what's being raised in the suppression motion. So, in short answer, it's just not kind of the response that I necessarily would write. But again, take what I'm saying with a grain of salt. I'm not counsel on either side, so I'm not privy to what they have, right?
We understand, and but we still appreciate your analysis, because I feel like you always think about it in a thoughtful manner, and and that's where we are too. I think anyone who's on the outside of this is going to have a limited view, and we're all just trying to analyze what we're seeing on the surface, but there may be other considerations that none of us are taking into account for whatever reason on both sides.
Right. One
thing I wanted to ask you was, and this is just spitballing, so I'm sorry if this is a convoluted view of this, but if we get into a situation where Alan said something like, "Oh yeah, I was there that afternoon," and it says, "Oh, you were there that afternoon," and afternoon defined as everything, post 12 p.m. ET, is that a situation where you could just have, it being a vague and non-specific kind of that matches up with what we need? Or would they need to, I guess could we just be seeing something like that where, he meant, yeah, I was there that afternoon, but left by 1:30, and the police need him to be there past 2:13 p.m. I don't know. Is that something?
Well, it certainly could be problematic during trial, and it could be problematic as it relates to the search warrant, to the affidavit. I don't know. I think if law enforcement needs to just put in, what's been provided to them and nothing more, right? And put in the material facts, even if it would diminish probable cause. That's what's required of them legally and nothing more. And if it gets granted, it gets granted. If it doesn't, okay. There's nothing that prevents you from going back and supplementing your affidavit with more information. So I always kind of find this troubling, that when you have these issues with search warrants, you could tell you're leaving out things. It's the analogy that I kind of make is, you're kind of in the middle of a movie. You didn't really provide the beginning. Just supplement it. You have the opportunity. It wasn't like, and I guess what makes this puzzling as well, it wasn't like there was an exigent circumstance going on, right?
Mm-hmm.
You're talking about a murder, okay, and it's transpired, and 5+ years that had passed. The guy lives locally. He's probably not going anywhere. Make sure you get it right and include all the material information. And it's just kind of perplexing why that wasn't done. Not to digress from your question, but, I've kind of raised this issue myself. I have trouble even with the address. Did they really connect the stated address to Richard Allen within the search warrant? I contend that they didn't really do that. And, that's a very easy thing to do. Just simply say, law enforcement checked, property or B&B records. And, this is the address, or we checked his ID when we spoke with him, and this is the address, or law enforcement went out there and spoke with them, or we spoke with neighbors. There was none of that. Now, there is a reference to Richard Allen allegedly stating that he had guns at that home. Can you make a reasonable inference that when he says at that home that he's referring to the address provided? I don't know. But I guess you shouldn't leave that up for debate, right?
Right. That makes a lot of sense. Were there any other things about this memorandum or the response to it that have stuck out to you as something everybody's missing in all the discussion of the more salacious elements?
No, I think we covered most of it, pretty much everything.
I was curious, do you have any thoughts on the issue of whether or not there should be cameras in the courtroom?
I personally prefer cameras in the courtroom. I think, to me, this case has essentially called for transparency. That's just my feelings on it. And I think there should be cameras in the courtroom. I think a lot of people were rubbed the wrong way of how initially things transpired, right? And this whole issue with the access to public records, the daily log, the safekeeping. I think pretty much they've called for cameras in the courtroom. That's just my opinion on it. It's not a legal argument. I get that, but I think it's all the more reason why there should be cameras in the courtroom.
Yeah, the weird secrecy is why we started reporting on this. Like, that was part of the reason we got kind of sucked in, because we were like, what is going on here? And we want to thank you for your help drafting the brief that we were able to get some of those documents released a few months ago. It feels like a million years ago, but it wasn't that long ago.
Right.
Yeah, but thank you so much, Shay.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
Botox Cosmetic, out of botulinum toxin A, FDA approved for over 20 years. So, talk to your specialist to see if Botox Cosmetic is right for you.
For full prescribing information, including boxed warning, visit BotoxCosmetic.com or call 877-351-0300.
Remember to ask for Botox Cosmetic by name. To see for yourself and learn more, visit BotoxCosmetic.com. That's BotoxCosmetic.com.